Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. And today I'm looking at a book which comes to us from WILDY, SIMMONDS and Hill Publishing. It's a special book and one I was delighted to be able to review. The title is called Court and Bold, Tales of Cricket and the Law, and it's been written by James Wilson. And it's a book which I think will be of great interest to anybody who has played cricket or been involved in cricket, and also of course anybody who's been involved in the law, because they are to a certain extent interlinked. Here's the book anyway. It's a paperback now. There's the front and there's the spine. Then you can see at the back there's some quite useful information. It runs to something approaching 350 pages. There's a very good index at the back. And what you do have is a very substantial amount of information all the way through. It's a very easy read. It's great fun. There are some footnotes and there's a little bit of law in it. There's some cases. There's the front page there. Then you've got the main front page here. And then after that you've got a very nice dedication, which I'll just show you there. Then after that you have some quotes from very well-known people. People whom anybody involved with cricket will remember. Neville Cardus. I don't think one will think of George Orwell in quite the same way, or Queen Anne, or Tsar Nicholas I. But those quotes are well worth reading. And there's a touching acknowledgement because this book, the paperback edition, came out after the hardback edition. And in fact, the author's father had died. So he's made some nice remarks about that particular matter. There are the contents section there, and then do read the introduction, which sets the scene very nicely before you get into the beginnings of cricket itself, running all the way through. I've loved this book, as you probably gather. I've been a cricketer. My father was a member of the MCC, so therefore I'm very proud to be able to have this book and to review it. What do I say then? I've said, well, it's a wonderful book for the cricket enthusiast, and so very English. And I'm saying that very bluntly because it is effectively an English game. I know that the Welsh and the Scots and the Irish and lots of other people play it, but initially it's actually an English country cricket match, and it's actually very much part of, I suggest, the folklore of Britain. So what do I say? Well, Lord Denning will be known to many of you, famously wrote, "In summertime, village cricket is the delight of everyone." And that was in a case which the author James Wilson comments was brought by someone who clearly disagreed with him. That's Denning and not Wilson. Now, for lawyers, we have some big cases. Bolton and Stone being the highlight for many covering the law of tort, and I'm sure many law students will remember with fondness the decision in Bolton and Stone. Of course, many cases exemplify how the game of cricket sometimes fails to avoid the law. And Wilson covers many situations common to lawyers and cricket watchers, including neighbours or passers-by who get hit by stray cricket balls, that's the case of course, protesters who interrupt matches, we know who they are, players who get into fights or take drugs, well, we know them, and though not considered in the highest echelons rather a few of those who are involved in the game who sue each other for defamation. And as I say, these people are well known to many of us. Now, the book, Court and Bold, first appeared as a hardback in 2014 with the subtitle Tales of Cricket and the Law, and it gave readers a flavour of the contents just by the title. What Wilson does is he covers stories where cricket and cricketers have given rise to a legal dispute. And of course there are more than one would think occasions where this happens. Do read the introduction, which is entitled Cricket, Justice and Non-Cricket, which I think is a splendid short history of cricket as it appears in early law reports, including a case which I didn't know about, I must say, dating from 1598, which apparently contains the very first known use of the word cricket. These gems appear regularly throughout the impressive text. That's why Lord Judge called it a gem. It's absolutely right with that. Now, Wilson then turns to specific cases from Victorian times onwards. Now, we, of course, as lawyers know that some of the disputes have been of fundamental importance to the game itself, and the famous decision which I've just referred to earlier, which is Bolton and Stone, affected village and indeed impromptu cricketers everywhere, says Wilson, and absolutely right. Because obviously it's about liability when you're having a match and someone gets hurt because the ball hits them or some property gets damaged. Now, Wilson continues in this vein, of course, writing about other matters, including the Australian Kerry Packer, who of course lost his High Court action in 1978 when the cricket revolution started effectively, which of course would have been over before a ball had been bowled had it not been for that decision. And of course some traditionalists were quite happy with the maintenance of the status quo, but of course the game has changed dramatically even since 1978. Now, other cases which Wilson cites raise issues going well beyond the boundary ropes, including the matter of Basil d'Oliveira and his omission from the England team for a tour of South Africa, which Wilson says, and there's a quote here, ended up being considered in the highest echelons of power in both countries. In other words, it could well have caused a major diplomatic incident. So you can see the boundaries are set very high indeed. Now, all these stories and sagas illustrate matters common to both cricket matches and court cases. And Wilson comments that behind the intrigue, entertainment and amusement of both, there are real people and real human stories with all the usual human emotions and fallibility. And of course that's what the beauty is of the game, and that's what we deal with in the legal profession. Now, the paperback edition has been updated for 2017. It's written in a clear, accessible style, free from legal technicalities, and it also includes the tragic death of Phillip Hughes, the perjury trial of Chris Cairns, and the ball tampering incident involving Faf du Plessis. Now, clearly the issues concerning cricket will continue, but at least we have a fairly up-to-date position concerning some of the more recent controversies. Let me conclude by saying a couple of things. I'm going to quote something from the book in a minute. It's a lovely book, in my view, for any cricket follower to own and to read, and we think it will be of interest not only to cricket fans or lawyers, as possibly as a Christmas present or whatever, but yet indeed to all who are interested in tales of high and low human drama, as he puts it, and the great ethical, moral and legal dilemmas. And of course, that is what cricket is all about, isn't it? Otherwise it just wouldn't be cricket. And I had to end on that point, but I'm going to end on another little point too, because right at the back of the book, the author talks about two primary threats to cricket. One is what he calls, the first is the law becomes too intrusive. And then the second, he says, is the threat that the law might fail to be intrusive enough. And he says, and this is, I think, a very telling point, the possibility of either is depressing enough. Then again, I can say one thing. Both dangers have been around for some time now, but they haven't happened yet. Since cricket has survived Grace's gamesmanship, Bodyline's brutality, Packer's plot, and the underhand underarm and all the other crises mentioned in this book, I suspect it might just survive for a while to come. I hope so. I'm sure it will. Lovely book, Court and Bold, and thank you very much to James Wilson and everybody involved, because this was a real treasure to find and I've really enjoyed reviewing it. Thank you to all. Bye-bye.